The case that I chose to discuss this week is Schiffman versus Spring. The plaintiff is Michelle Schiffman and the defendant is John Spring and Fred Bright. This case originally started off as just one defendant, that being John Spring. However, as the case progressed, Fred Bright was added as a defendant as well because he was present at the time of the injury and at the game that it happened at. This case took place in the New York Supreme Court in their Division IV in 1994. So, just some basic facts about the case. I found it really interesting just from the very beginning that the case states that the New York Supreme Court should have granted the motion of the defendants for summary judgment dismissing the complaint. A summary judgment is basically where both sides submit evidence and then the judge reviews that and there's no need for a trial and he makes a decision off of that. So for that to be stated in the case study is really significant because it shows that there should have been enough evidence prior to this case going to trial that the judge could have made a decision. And obviously that's not something that's really common in a lot of court cases because if it were, then it would be very easy to come to a settlement. The plaintiff in this case, Michelle Schiffman, she was also a female soccer player, so that's something that really attracted me to the case and made me want to read more about it and discover more about the facts and exactly what took place. Michelle Schiffman, the plaintiff, was a member of the State University of New York at Brockport's women's varsity soccer team, and she was injured on September 22nd, 1987. So 1987 and 1994, that's a big difference in years, but really in the court system, that's not a long time. Obviously, in any court decision, you want to make sure that the plaintiff and the defendant both have time to submit all of the evidence that's really necessary and that documents that have been requested have time to make it in. The judges aren't really going to make a rash decision really quickly in a case where someone's being sued or asking for money, especially because that's something they really want to take into consideration to make sure they're making the right and the most fair decision for both parties involved. Since her case was a personal injury case, also, that's going to slow it down a little more as well. Her injury took place when her foot got stuck in the mud on a playing field while she was participating in a soccer game at the State University of New York at Geneseo. And in her complaint, she states that John Spring, who was the athletic director at Geneseo, and Fred Bright, the head varsity women's soccer coach at Geneseo, are to blame for her injury. She states that both were negligent in allowing the game to take place on a wet, muddy, and slippery field. As a soccer player, those field conditions really aren't that uncommon. Unless it's lightning or just pouring down rain and nobody can see, a soccer game usually is not going to get canceled. So this is not something that the plaintiff would have not been used to. And it's something that she probably played in for several years, considering she was now a college soccer player. Schiffman was aware of the playing conditions when she started to play, so trying to claim that the athletic director and the coach were negligent in allowing her to play is really not going to hold up in court either. She knew before she stepped on the field what the risks were and that she could become injured. Thinking back on my career, the last game of my senior year, it was really wet, it was muddy, the field wasn't great, but it was the last game of my senior year, so obviously I'm going to go out there and play. Ended up tearing my knee. Did I sue the university that I played for, the university that we played against? No, because I knew the risks before I stepped out onto the field and I chose to participate anyway, and there's going to be consequences because of that, whether they be positive or negative. That's just going to kind of be, up to chance, whatever happens during that game. And as a college soccer player, you should be able to have enough resources to prevent yourself from injury, but then again, sometimes they're just going to happen by accident. Since Schiffman was aware of the conditions, she even told her teammates and her coach how bad the fields were before she stepped on the field, yet she still decided to play. So again, that's her voluntarily showing her choice to play in the game regardless of what the field was like and how wet and how muddy it was. In an examination of her foot that happened before the trial of this case, she even stated to her doctor that she was fully aware of the conditions and the risks involved. And in a lot of court cases, especially with personal injury, the medical records can be subpoenaed to court, and this is something that you can refuse to do. However, if the judge grants it, then you have to turn those over. And obviously with a personal injury case, the judge is going to want those records so that he can see what the doctor said about your injury as well. Because the doctor is either going to say that, you knew the risks and this is your fault, or these people didn't take the necessary precautions to make sure that you weren't injured. So since Schiffman voluntarily chose to play, she put herself at risk in the conditions. No incident occurred during the first half of play, and she voluntarily returned to the field for the second half. So this is twice that she has stepped onto the field and chosen to play, even though she was aware of the risks and the dangerous conditions that were involved. She sustained her injury shortly after the second half began and had to be removed from the field and could not return to the field of play that game. As a general rule, in sports, participants must give their consent, which is seen in Schiffman's participation when the conditions are seen to be dangerous or just not great to participate in. And in order to establish assumption of risk, which is how risky was it should have been allowed to play, Spring and Bright had to prove that Schiffman was aware of the risks involved before she participated in the game. However, they don't have to show that she foresaw the injury that would happen. A lot of the times, you know that something could happen to you, an injury could occur, but you don't know what exactly and what injury could happen. When I think back on my career, when I tore my knee, I thought, hey, I might get hurt, I might twist my ankle. I didn't think that I would tear my knee. However, that's what happened, just the consequences of the game. It's just something you put yourself up to every time you step out on that field, regardless of the playing conditions. The conclusion and the judgment that the judge makes has to be made on the obviousness of the risk, and then also taking into consideration Schiffman's background, her skill, and her experience in the sport. With her being a college soccer player, obviously she had a lot of experience in the sport. So this isn't something that she was just going to go out there and not do, or go out there and do and not know what was going on. And then also take into consideration is how Spring and Bright conducted themselves before, during, and after the injury. The most important fact to remember here is whether the risk is inherent in the activity. So if it is, then that's just something that goes along with the sport and what happens when you participate in this sport. The defendants wanted a summary judgment to be made from the very beginning, and they submitted admissible evidence to show proof that the plaintiff made a conscious choice to participate after evaluating the risk. And the evidence the defendants submitted proved that Schiffman voluntarily participated in the soccer game and that she was completely aware of the field conditions and that she could become injured. The evidence also proved that the defendants were not negligent in their duties and that the injury was simply an accident and that they took all the precautions necessary prior to the game beginning. During this time that they were submitting evidence, the plaintiff failed to dispute the proof, and therefore her complaint was denied and their motion for summary judgment was granted. The order in the New York Supreme Court made it unanimously reversed the law that she was claiming the risk of injury, and there were no costs assigned to either party. Neither party had to pay each other for what occurred that day. And then the defendant's motion for summary judgment again was granted. So in this case, the defendants won. The implications for the AD here are just that you really need to think about what the conditions of the playing field are. Some judges may have seen that the AD and the coach here should have canceled the game. Again, with it being soccer, it's not something that usually happens unless there's lightning or just a downpour where you can't see. But the implications for the AD that can come from this too are that girls coming into the program, are you going to take care of me? Are you going to make sure that I'm taken care of and that I'm not going to fall to injuries because of a decision that you've made to play in a game where it could be dicey, it could result in injury. So here the AD just has to make sure that they're really taking into consideration the risks and the factors that are involved in making sure that all of the players are as safe as they can be and that they are making the conscious decision to play in the game.